Officer Day, would you open my courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. All right, let's see who we have here today.
Cyril Hall is present on Vantage versus Gooch and Son Towing.
Who's still on that file?
I don't see the opposition, Mr. McLean, yet.
Okay.
Oh, yes, I do. Yes, I do. Yes, I do. So we're ready.
Okay, then you guys, everybody else is off to the waiting room. All right, we are on the record. We are calling case number 20168-231, Vantage International Shipping versus Gooch and Sons Towing. Your respective appearances.
Thank you very much, Your Honor. Good morning. Cyril Hall on behalf of the plaintiff.
Bar number.
29-121.
Good morning, Your Honor. Dan McLean, P72982 on behalf of defendant Gooch and Sons Towing.
Okay, gentlemen, this is our second pretrial. Is our discovery done on this one? Discovery's been open for a while.
Your Honor, there are.
Go ahead, Mr. McLean.
Thank you, Mr. Hall. There are. I do want to say I do appreciate that Mr. Hall did keep his discovery short and succinct. I hope he believes we did the same. There are a couple weeks left on some requests he has over to us. I'm still waiting on a few things from my client. Once I get those back, I can get those over to him.
Okay, so we seem to be moving along with our discovery. Is that about right?
Yes, Your Honor.
Okay. Now, here's the thing. Since we're doing everything remotely, I cannot get you up to my bench and bang your heads together. That's how I used to settle cases. I know. So for now, let us just do this. Let's give you a return date and let's get that discovery completed. Can we go to June 10? June 10? Does that work for everybody?
Yes.
Mr. McLean?
Your Honor, it does.
Okay, June 10th at 10 o'clock, we will have another pretrial. It'll be on Zoom again. Let's get our discovery complete. So I'll simply leave your discovery open for now. Is there anything else we can accomplish today?
No, thank you, Your Honor.
Anything for you? All right, gentlemen, we'll mail out your order. Thank you both for coming in. Please be safe. We're off.
Thank you very much.
Thank you, Your Honor.
Looks like
Good morning, Ms. Harris.
Good morning, Your Honor.
What brings you here today?
I am here for the defendant in Bartholomew versus MJ Realty.
And you've got Jones?
Yes, sir, Your Honor.
Yeah, I think I have Mr. Bartholomew. We can get started.
Yes.
All right, we are on the record calling file number 20240-638. The file is entitled Louis Bartholomew versus Marcus Jones. your respective appearances.
May it please the court, Your Honor, Esther Harris, P83394 for the defendant, MJ Realty, and he was present earlier. I'm not sure if he's in the waiting room now.
What's his name? Marcus Jones?
Yes, Your Honor.
I think he's here. Let's see if we can't get him in here.
Thank you, Your Honor.
All right, I have Mr. Jones here. What is your name, sir? No, you're muted. Try it
Oh,
again.
sorry. My name is Louis Bartholomew, appearing as the plaintiff, representing myself.
Okay, now, and you are Marcus Jones?
Yes, sir.
Okay, here's what, gentlemen, we're going to do here. Mr. Jones will be muted because he has counsel. Now, Mr. Bartholomew, this is the first pretrial on a case that was started in small claims. This is not the small claims division. This is now the general civil division. The rules in the small claims division are very different than the rules in general civil. In general civil, you must comply with the Michigan court rules, the Michigan rules of evidence, Michigan statutes, and Michigan case law. In the in the small claims division, none of those things, with the exception of the rules of privilege, apply. The judge is not in small claims obligated to strictly follow the law, but is to do, quote, substantial justice. That is not where we are now. The general civil division is much more formal. And whether or not you know the rules, whether you know the rules of evidence, whether you know the rules of civil procedure, you will be held to having that knowledge. There's only one set of rules here. Do you understand that?
Yes, I do, Your Honor.
Okay. First thing I would recommend to you, and again, let me make this perfectly clear, you have an absolute constitutional right to represent yourself. But I would urge you, now that you are not in small claims, to get counsel. So, have you guys had any conversation on this file, or are we just still early on since the file has been removed to general civil?
Your Honor, we did try mediation prior to this case being filed, but since then there's been no resolution. So we would like to go forward with trial.
Okay, then what I'm going to do, since this is a case coming over to me from small claims, your written discovery is open. It has been since March of 2021. What has been done by way of written discovery?
Your Honor, so far we have exchanged requests for admissions. We've exchanged some picture evidence, and on, I believe it was either Monday or Tuesday, Mr. Bartholomew, correct me, Mr. Bartholomew sent me his witness list.
Okay. Have you guys completed your written discovery, or do you need more time for written discovery?
I need to send a witness list, but other than that, my written discovery is done.
All right, Mr. Bartholomew, how about you? Are you done with your written discovery?
Yes, I am, Your Honor. I sent to the defendant's lawyer, I sent my own request for admissions, request for productions, and my witness list.
Okay, then what I will do is I will give you a return date, and that date is June 10th. Does that work for everybody?
Give me 1 second.
It'll be on Zoom again like today. I don't think I'm going to be in person for quite a while, if the rest of this year, quite frankly.
I agree. Your Honor, do you have anything on the 9th or the 11th?
Let me see. The 9th. Oh, it's on the 9th. I can do the 9th if you want to do that. Does that work for you, Mr. Bartholomew?
Yes, June 9th works for me, Your Honor.
Okay, June 9th at 10 o'clock it is then.
Thank you, Your Honor.
And the pretrial will be on Zoom again like today. And your written discovery will close on June 8th. So by the time we're next together, our discovery will be all completed, okay?
Yes, Your Honor.
Yes, Your Honor.
Today?
Yes, Your Honor, procedurally, how do you wish to receive the evidence in this Zoom era? What's your procedure?
At this point, I quite frankly haven't made my decision on that.
Okay.
Because we're having trouble both with people sending in things by the mail, they'll show me a mailing receipt and nothing's been received. So I think it might be premature at this point in time. I should tell you, I do not anticipate, is this a bench or jury trial?
Bench.
I don't anticipate being able to give you a trial this year. See, the problem that I have is you're just coming online and I have people backed up ahead of you. And the problem that we have is, as you know, everything's basically gone to hell in a handbasket since last March.
Yeah.
So before we start worrying about transmitting evidence, let's get our discovery complete. And then let me both talk to both of you just in general. Business disputes are just that, disputes about business. We're not curing cancer. We're not solving world hunger. We're not fixing world peace. The way we settle business disputes, the way most cases settle, is that we have unhappy litigants. Defendant says, I paid too much. Plaintiff says, I didn't get enough. If everybody's unhappy, we're probably where the case ought to be in terms of resolution. Given the fact that it's going to be quite some time before I can give you a trial, let me urge you to think about resolution. One thing you might want to consider, and I don't know, particularly since you've already had a mediation, if this makes any sense to you, if you might want to consider a facilitation. But again, as you indicate, you've already had a mediation, might not make sense to you. But right now, let's finish our discovery, but let's put in the back of our minds the idea that probably we're going to get this matter resolved, and we're going to get it resolved by everybody being unhappy. Okay?
Yes, Your Honor. Thank you.
Yes, Your Honor.
June 9th at 10 o'clock, we'll we'll have our next pretrial, and your discovery will close on June 8th. You folks, thank you all for coming in. We're now off the record.
Thank you, Your Honor.
Thank
Have
you,
a
Your
great
Honor.
day and be safe.
You as well.
You too.
We are on the record calling case number 20167-437. This case is entitled Midland Credit versus Davon Snell. Excuse me. This is our second pretrial. Your respective appearances.
Davon Snell on behalf of Davon Snell.
Your Honor, William Hill, coverage attorney on behalf of Midland Credit.
Bar number.
P28608.
All right. Have you guys been able to resolve this thing?
No, sir, we haven't. I wouldn't mind talking to Mr. Snell in a breakout room if that would help.
Mr. Snell?
We can talk.
All right. What I'm going to do is I'm going to open your written discovery. I'm going to open a breakout room and send you guys there now, okay?
Okay, thank you.
Well, let me rephrase. I'm going to try to open a breakout room and send you there.
Okay. Let's see.
Okay, create open rooms, open all rooms. Mr. Hill,
Yes, sir.
I think I got you in the room.
Okay. Sure.
Yep, got it. All right, gentlemen, we are back on the record in 20167-437. Midland Credit versus Davon Snell.
Your
Gentlemen,
Honor,
are you able to
Your Honor.
resolve? Yes, sir.
Your Honor, I cannot see you, Your Honor. I don't know if it's mine or yours.
Nope, it's mine. Thank you.
Okay.
Were we able to resolve it, gentlemen?
No, sir, we're not. Mr. Snell has given me an offer that I want to write up and convey to Midland Credit, okay?
Okay.
I don't have the authority today to offer it, but we're moving, and he made an offer that I'm going to write up and convey to them. I noticed that this is a second pretrial in the matter, and apparently Mr. Snell wants some verification of the ownership of Midland, actually being the owner and the creditor entitled to pursue the action.
All right, well, what I'm going to do is I'm going to open your written discovery and I give you gentlemen another date.
Okay, thank you.
June 10th, work for both of you?
Yes, sir.
June 10th,
Yes.
10 o'clock.
June 10th, 10 o'clock. Your Honor,
Yes,
if I speak with Midland, if they reach out and we come to agreement on the settled terms today, we still show up at court, correct?
if you have everything settled and the paperwork is submitted, then you need not do that. But, you know, typically the way that works is there'll be some paperwork that has to be exchanged, signed by both sides and turned in. Otherwise, I'll expect to see you on June 10th.
Thank you, Your Honor.
Gentlemen,
Thank you, Your Honor.
we're off the record.
Yeah, have a great one.
Have a great one.
Okay, we can leave, right?
35.
Well, I don't think she wants, I asked her.
Got it.
Who is DMCQ?
My name is Donita McQueen. I have a 11 o'clock court case.
And Mr. Crankerville, what brings you here today? Best Buy? Best Deals Auto Sale?
His auto sales, Miss Shields. Yeah.
Okay, so you're not with Ms. McQueen.
No, sir.
But I don't, Ms. McQueen, what is your case number?
Case number is 20156-539.
Let me call and check something for you just a second.
Okay.
Ms. McQueen,
Yes.
May 13th is your date, not today. May 13th at 11 o'clock is your date, ma'am.
Oh, I put the wrong. Oh, I thought you said the 6th. Because
No.
you wasn't pushing it all the way out. You told me the 6th on the court date that we had last time.
Yes, May 13th.
Okay, May 13th. Okay, thank you.
Yes, ma'am. Have a good day.
You too, bye.
Bye-bye. Mr. Stratton,
Good morning, Your Honor.
you've got Dearborn Automotive versus Ariana Fleming.
I do, Judge.
Okay, I don't have her as of yet. But Mr. Cracksville, I have your opponent now. She just checked in. So, Mr. Stratton, you're going to the waiting room.
Hey, Judge. I actually have a returned consent judgment from her, so she might not be showing up. I sent the consent judgment in the mail yesterday.
Okay, then let's call your case then, and we can just handle it right now. So there'll be no reason to hang on for a second. You're at 526. Okay. We are on the record. We are calling case number 20160-526, Dearborn Total Automotive versus Ariana Fleming. This is the date and time set for our pretrial, your appearance.
Yeah, good morning, Your Honor. Trevor Stratton, P65124 on behalf of the plaintiff.
And Mr. Stratton, I believe you told me you've got a resolved case here.
Yes, Your Honor. The case is resolved. Ms. Fleming returned her consent judgment, and I have also signed it and forwarded it to the court as of yesterday.
Okay, then what I'll do is I'll simply enter a dismissal without prejudice, noting that the executed consent judgment is on the way.
And that dismissal would automatically be set aside upon receipt of the consent judgment?
Correct, exactly right.
Okay, that works.
Okay? Thank you
very much.
Wait, hang on. Ariana. I think I have Ms. Fleming here. I think she just checked in here. Hang on, let's see if this is her. All right, are you Ariana Fleming?
Yes.
Okay, Ms. Fleming, I have Mr. Stratton on the line. He advises me that you guys have reached a consent judgment and the paperwork has been sent to the court. So we're all set and we'll get that copies of the consent judgment back to you once they've been received by the court, okay?
Okay.
Have a good day. Mr. Stratton, thank you for coming in.
Thank you, Judge.
Thank you, ma'am, for coming in. You have a good day.
You too.
I'll be safe.
Too.
All right, we are on the record calling case number 21144-270, Best Deal Auto Sales versus Virginia Shields. This appears to be pretrial, our second pretrial, your respective appearances.
Morning, Your Honor. Brent Credible appearing on behalf of plaintiff, Best Deals Auto Sales,
Bar number.
P75845, Your Honor.
All right, and what is your name, ma'am?
Virginia Shields.
All right, where are we on this file? When we were
Your
last,
Honor,
you were repossessing the vehicle, correct?
yeah, this is actually, I think, the third time we've been here. So after the first pretrial, yeah, we had an agreement where we would be repossessing the vehicle, and we would be doing a stipulated dismissal of this case with a settlement agreement.
And I'm still waiting.
We did repossess the vehicle.
Right.
And Ms. Shields, I think, lives close to where the car lot is, and has indicated, it's still on the property or the property next door or something to that extent. And she was given credit for the vehicle in the amount, like in a salvage value. And my understanding is she has an issue with that. I spoke to my client about why it's sitting next door. I did call Ms. Shields and leave her a voicemail with that information. I haven't heard back from her, so I'm not sure what her position is at this time.
Well, if I may, Your Honor, the problem is I have no problem with settling, but if the car was actually salvaged and it was still at $600, it's still, as of this morning, sitting on the repair lot of Best Deal Auto. So I think what you told me, Brent, was that is taking that long for them to actually come pick it up. But I mean, it's literally sitting at their repair shop as if it's waiting to be repaired. And this is 2 months later.
What's going on this?
And I understand that my client indicated that I don't know what salvage yard it is. I don't know how it works. They were paid for it via salvage, and they're waiting on them to come pick it up. They don't have any room on their lot. So it's next door where the repair facility is. And I don't know this, but Ms. Shields sounds like has seen the car numerous times. Has it always been in the same place? And has the car moved?
It's been in the same place. But it's at their repair shop. And for me, I thought if a car is being salvaged, and I mean, do they at least have a salvage receipt or a title for it?
I do not know. I should be able to get.
I just want to do whatever's fair. I mean, I don't want to pay for a car and then they're going to resell it and get extra money on it, and I'm still paying for it on top of whatever I paid.
Okay. Counsel, I need you to take more active interest in this file with your client. Either they're going to repossess it, and they told me they have, then by now they should have the title for the vehicle. How long ago did the repossession occur?
2 months ago, Your Honor. And
It happened.
You're saying about salvage title. Yeah.
Yeah. So where's the title?
I don't have it on me, Your Honor. I can call my client and get that.
Well, we need to get this file moving. Because
I understand that, Your Honor. We have a stipulated dismissal that's been sent to defendant that defendant has had for months now that has not signed. We're willing to do a stipulated dismissal.
What's the hold up on that, Ms. Shields? What's the hold up on the stipulated dismissal?
That's the agreement that I paid, the $600. That's whatever court costs and everything. But they only gave me a certain credit for the dismissal, the salvage of the car, but the car have not been salvaged.
I think there's just maybe a confusion as to the definition of when a car gets salvaged. It's sold for salvage value. That the salvage yard hasn't physically taken possession of that car, in my opinion, is irrelevant. But obviously, Ms. Shields does not agree.
Well, here's what I'm interested in. Is there a document that Ms. Shields can get that shows her the vehicle was sold for salvage at this price? That appears to be her concern.
Yes.
And
I don't think she's concerned about the physical location of where the vehicle is.
Sure, I understand that, Your Honor. Yeah, there should be, and I should. That makes sense, Your Honor.
Because we're spinning our wheels here.
I agree.
All right, I'm going to give you guys one more day here. June the 10th work for both of you?
Yes.
I believe so, Your Honor. I'll make it work.
All right, June the 10th at 11 o'clock, we'll do this again. It's time to get this file resolved.
Yeah, 11 o'clock. Yes, I will. I'll get any documentation I can from my client, Your Honor, and forward that to Ms. Shields. I believe I have her email, or
Okay.
either way, I could give her a call anyway. So
Okay,
thank you, Your Honor.
thank you both. Be safe,
Thank you.
both of you. Thank you.
Thank you.